As people are joining us, just a quick welcome to everybody. Good morning, good afternoon, good evening. We're excited to have you join us today for our webinar, our Ask Us Anything, Understanding the Impact of the U.S. Executive Orders on Pay Equity. We're going to get started with a couple of housekeeping items. First, my name is Katie Bardaro. I'm our Chief Customer Officer here at Syndio, and I wanted to ensure that you understand we have our greatest legal minds on this call, but we are not providing legal advice. The information that we are providing is meant to be used for informational purposes only. If you are interested in a live transcript, you can turn on the closed captions setting found in your Zoom toolbar along the bottom of your screen. We are, for privacy purposes, disabling attendees' audio and video, and the attendee list has been hidden. We're spending a large portion of our time today on questions, so please have those questions ready, and you can leverage the Q&A feature within your Zoom toolbar to submit questions at any time, and we'll do our best to answer them during the session and then follow up with any unanswered questions after this session. This webinar is being recorded, and we will be sending along a link to the recording as well as a copy of the slides that we're covering today after today's sessions. Lastly, please let us know your thoughts on today's webinar in a short survey that will be following this presentation. And then as a quick overview for those of you who are attending who are not familiar with Syndio, I wanted to share that Syndio is the leader when it comes to measuring, achieving, and sustaining pay equity and pay transparency. We're incredibly lucky to work with over 350 leading organizations, many of which you can see on the screen here today. And across those customers, we've analyzed data for more than 10 million employees, gathering valuable insights, some of which we'll show with you here today. What truly differentiates us as a solution is a mix of both sophisticated technology solutions and expert advice and support spanning legal and economic best practices, as well as custom statistical analyses, reporting, and communications. Joining me today, we have two fabulous panelists. First, we have Rob Porcarelli, our Chief Strategy Officer and Chief Legal Officer here at Syndio and former VP Assistant General Counsel at Starbucks, where he led teams responsible for all labor, employment, and EEO issues, as well as general litigation. Joining Rob, we also have Christine, our VP of Strategic Initiatives at Syndio. With over 20 years of experience in employment law, Christine works at the intersection of HR analytics and the law. She partners with employers to provide strategic, practical, cutting-edge, and real-world best practice advice on pay equity and global regulation topics. And prior to joining Syndio, Christine was a partner and co-chair of the Pay Equity Group at Seyfarth Shaw. In today's conversation, we're going to provide an overview of the impact of the U.S. executive orders on pay equity, why pay equity remains crucial, considerations for legal compliance, and then spend a majority of the time on the Q&A. Before we start, I'm going to turn it over to Rob to drive a poll question.
Okay, just to get things started and to make sure that you're awake, if it's early morning and you're having coffee, just take a moment. And we'd love to know, in terms of if you're US based, with the onslaught of executive orders that we'll talk about in a moment, what's your organization's commitment to pay equity? Just generally speaking, you leaning in, you staying the course, you're undeterred, or are you pulling back? We'll give folks a moment. Don't worry, we won't record who you are and how you're answering. So if you say we're pulling back a bit, it's not gonna be subject to discovery by the administration. And I see we've already got a question, by the way, but we will get to that question about UK gender pay gap at the appropriate time. Okay. And then, oh, look at that. Live in real time. Most staying the course. Some leaning in. Amazing. Less than 5% pulling back. Okay, that's awesome to see. We're good. We should end the webinar right now. I'm kidding. All right, let's do it. So it's a complex landscape that you all are facing, we collectively. For those of you with an EU population, right now there are regulatory tailwinds pushing for greater disclosure, mandatory disclosure, pushing for greater transparency. And we're getting a ton of questions. Christine and Katie are spending a ton of time fielding questions around how do we communicate about pay, and how do we manage the change associated with all this reporting. Meanwhile, in the US, a little bit of headwinds in terms of the executive orders that are started hitting immediately after the inauguration, I think January 21 or something. And then, broadly speaking, we're seeing a theme where companies are facing a little greater pressure to prove that they're a meritocracy. Now, the proponents of DEI would say that's why DEI was established, was to ensure that we really do have a meritocracy. The opponents of DEI would say, well, no, we elevated identity over things like skills and merit, and that's why it's in the crosshairs of the current administration. But wherever you are in that spectrum, there is room for you in the debate. Let's go forward there, Katie. Thank you. All right, so for the pay equity landscape, I mentioned the executive order that we'll talk about in greater detail. It does not address pay equity. It talks about ending illegal discrimination and restoring merit-based opportunity. What does that mean? It's a little bit in the eye of the beholder. But what we're seeing is a lot of customers taking account of their DEI practices to ensure that they're not engaged in, and I quote, illegal DEI. The EEOC has seen the early term of two commissioners. Those of you who are facing EEOC charges currently, you might have noticed a real slowdown in terms of the processing of those charges. That's definitely a trend that's happening. And then, of course, we still have the same regulatory and legal landscape. State and federal laws are still in place to ensure anti-discrimination, equal pay, or at least pay not impacted by race and gender. And then there's more and more pay reporting laws that'll come online. Let's talk about what's changed, and then we'll talk about what hasn't changed. So what's changed? The OFCCP has been gutted. Katie mentioned I had one of the things that I did before Syndio is I had the EEO function, and for those of you who have our federal contractors, it might be that right now those the folks who in-house prepared affirmative action plans are wondering what they're going to do. Affirmative action plans for vets and disability have been maintained, but the rest has been gutted. They're on hold. Auditors were told to stand down. And included with that is the requirement to conduct annual pay audits. We still see our large federal contractors continuing with pay equity because, of course, we'll talk about why in a moment. There's a renewed focus on, quote, illegal DEI, and federal contractors may have to certify that they don't have any illegal DEI programs. That's the subject of litigation right now. Those are the lines at the bottom of the slide because that executive order was issued. There was a lawsuit. It's been blocked. It's been lifted. The only thing that seems confirmed at this point is that litigation will continue. So we'll see where that ends up. And then the EEOC currently lacks quorum. And that's kind of significant. Christine, what would you add here in terms of what's changed under the current administration?
I think that the biggest thing that I would say is that we're finding that employers are thinking about things a little bit differently. And a lot of that has to go with what's happening, I think, with the court orders and the court challenges that we're going to talk about in a little bit more detail. Do you want me to jump right into that, or do you want to?
Yeah, please.
Yeah, perfect. So we can give you a little bit of a sense of what's happened. So on January 21st, President Trump issued the illegal DEI executive order. And so that executive order had kind of many different component parts, but three of them were something that was called kind of three core parts other than the OFCCP was this was what they call the termination provision. So this said that every agency has to terminate any equity-related grants or contracts. There was also what they called the certification provision. And that certification provision said that if you were a federal contractor, if you were an employer that was doing work with the federal government, that you would have to certify that you are in compliance with the federal anti-discrimination laws and that you're not operating any illegal DEI any illegal DEI programs. And then the last one was this enforcement threat provision, and that ordered the Attorney General to submit recommendations and a strategic enforcement plan to challenge illegal DEI in court. So what happened after the executive order was issued is that there was fast follow on litigation, not unexpected. And so after that case was filed, it was heard by a district court in Maryland, a federal district court judge in Maryland. And the federal district court agreed with the plaintiffs that were challenging that illegal DEI order, specifically those three provisions: that termination, you cut the contracts, the certification that you had to say that, yep, we do not have any illegal DE&I programs, and then that enforcement threat provision, so that looming potential criminal and even civil and even criminal penalties. And the court said that they agreed with the plaintiff that those were unconstitutionally vague. It wasn't clear what was meant by illegal DEI, and that it also constituted content-based and viewpoint-based discrimination, so that people that had, certain views, that it was protected speech, and so therefore it violated the First Amendment's free speech provision and also the Fifth Amendment, and so that was about the fact that it had content-based or viewpoint-based discrimination. And then the second one is that it had that it didn't provide due process under the Fifth Amendment because it wasn't clear, it was too vague as to what was meant by illegal DE&I, and especially with respect to the enforcement. Okay, so that happens, gets challenged in court. Judge in Maryland on February 21st puts those three provisions. So the OFCCP still gutted, that wasn't impacted, but the termination, the certification, and the enforcement threat provisions all were blocked. Not surprisingly, that was appealed and then heard by the Fourth Circuit. So appealed one level up, and a 3-judge panel heard the appeal from the district court decision. And all 3 judges, and it was a unanimous ruling, lifted the stay that was blocked by the district court. Those 3 judges came at their decision really differently. So there were 3 judges. One was appointed by President Biden in 2023. That was the chief judge, Albert Diaz. There's a second judge, Pamela Harris, who was appointed by Obama in 2014. And then there was a third judge who was a appointment by President Trump in 2019, Allison Rushing. So Judge Diaz, Harris, and Rushing all agreed that the termination provision, certification provision, and the enforcement threat provision could proceed. 2 of those judges, though, expressed really a lot of concerns with the government's anti-diversity agenda, even as they paused the ruling. So they said that they felt like it could go forward in the limited way that it was offered, but they suggested that the efforts to promote diversity should be praised, not attacked. And so at this point, kind of where we stand right this minute, is that the illegal DE&I order is moving forward, although we will likely see appeals up to the Supreme Court. Also know that there were a lot of court cases that were filed challenging the illegal DE&I. This was just the first one to get to a point where there was a ruling. So it's likely that we're going to have more district courts, maybe more circuit courts potentially reaching different conclusions with these illegal DE&I order. And this is something that we'll ultimately likely see in the Supreme Court if, as anticipated, we end up having different decisions that are reached by different courts at both the district court and in the circuit court level. So a little bit of confusion in terms of where this is all headed. The OFCCP, that provision, that portion of it wasn't part of this litigation only focused on mainly around that certification and those potential civil and criminal penalties. So more to come.
Christine, speaking of the OSCCP, we actually had a question that came in that I think would be timely to ask now, which is for federal contractors with open audits and ID under the newest, under the Biden administration, do they consider those closed, or should they wait for further instruction from the OFCCP?
Disclaimer,
Yeah.
we're not your counsel.
Yeah.
However, you should check with your counsel.
Mhm.
But everything I've seen is that those auditors were told to stand down, and auditors who are in the midst of open audits were told not to go on site. So I'd check with your counsel if you have one, or the auditor if there's one assigned and you know who that is. By the way, we'll address a number of these questions. I see them coming in when Christine was explaining. When Christine and I talk about the void for vagueness thing, I think the one thing that's for sure, litigation will continue. So too, I think Michael's question, Michael asked in another Syndio event last year, we talked about significant changes being unlikely to be immediate
At the EEOC.
because of the Democratic commissioners. Now they were fired. Is that ability to fire normal course or challenged? I'm right now, nothing's normal course. So there's no normal course, and are they likely to be challenged? Yeah. I mean, right now we have litigation everywhere. That's much litigation that's even much broader than what we're talking about here, right? There have been law firms that have been the subject of executive orders. That's a subject of litigation. We have terminations at the federal level, led by the DOJ department. Those are the subject of litigation. So litigation will continue. I do think, the litigation with the void for vagueness thing, they have to be careful. You want more specificity on what illegal DEI means? If I'm in the administration, I'd say I can give you all the specificity I want. In fact, we'll share a list of naughty words that the New York Times got a hand on, that the administration has issued. So the one thing that is for sure, litigation will continue. That creates uncertainty for you all. There was a question about Naveen had asked, do companies risk legal challenges if they continue internal DEI focused compensation reviews? How should organizations navigate this? If this order is overturned, do we get back to a smooth transition to stronger pay equity initiatives? I would say, I mean, I don't know what a DEI focused comp review is. We help our clients and customers conduct pay equity analyses. And so if maybe what I'm interpreting is the question might be, do you only remediate one group or another? I think what's clear, regardless of the orders and the fight right now over DEI or illegal DEI, is if you find a group that is disfavored because of race or because of gender, I'm not your lawyer, but I think most counsel would say you should remediate it. There are companies, and we're going to ask you in a few slides, whether you've seen this, that might say, I'm only going to remediate when women are disfavored, or I'm only going to remediate if non-white employees are disfavored, and non-white and Asian are disfavored. If that's what you mean by DEI comp reviews, that would be problematic, because again, remember that the protected categories are race, not one race. The protected category is gender, not one gender. But let's keep moving, and I'll keep an eye on the questions, and maybe Christina and Katie, you can keep an eye on them so that we make sure that we address them.
Absolutely.
And then there's a great, Rob just wrote a really great article that appeared in Newsweek, that our team is gonna drop into the chat in just a second, on kind of how that impacts how you're approaching pay equity as well. Yeah, thanks, Mark.
I also mistakenly mentioned a couple first names. I will not do that again. So if you send any questions, my apologies.
If you put in your chat, if you put the questions, if you don't want your name to appear at all, put the questions in the Q&A section. It comes in as anonymous. If you put the question in the chat feature and you add your name to that, then we will see your name. So if you want to ask a question where no one can see your name, please put it in the Q&A, or just remove your name from the as you're filling in the chat, so that we won't see it as well. We wanted to make sure that everyone had many ways to ask questions without having names attached. So feel free to do any of those things.
Without me adding anyone. Okay, there we go. I'll stop that. All right. So what hasn't changed? And this will address a couple of questions too. Laws, executive orders are presidential orders, but they don't change federal law. So the Title VII still exists. There's a number of state laws that are still on the books. There's the Equal Pay Act. The EEOC's core function hasn't changed. And this is critical. So in terms of one of the questions was pay equity is not DEI. Do companies get this? Great point. Absolutely. And that's what we're seeing as well, is that companies are continuing with pay equity, but it's just the onslaught of executive orders was so rapid and so immediate that there was a quick pause to go, what's in scope? Because it was so unclear. It was so vague, when folks were saying illegal DEI, which some interpreted as everything related to race and gender. Christine, anything you'd add here as well?
I think that you're really covering it. I think that the biggest thing that we're seeing is and we're going to talk about it in a lot more, is just that there's a lot that continues to move, and in many ways it's much more impactful. So it's interesting that we're getting lots of questions about global pay reporting laws and global pay equity, and the fact that those things feel so interconnected, I think is a big piece.
The New York Times ran a piece saying these are the words disappearing in the Trump administration, and I don't, you can see it's fairly broad. The word women is on this list. Privilege, I guess that would mean anyone who does anything under privilege. Race. So, but just know that right now the administration seems to be on the watch, concerned that companies are engaged in their view of illegal DEI is where you make selection decisions based on race or gender and not something else. You make a decision based on a protected category. And so that seems to be really what the administration is most focused on. Note that pay equity is not a phrase that the Trump administration is going after. Let's keep moving here. And right now, in terms of litigation that's happening, it's mostly about selection. Like I said, am I going to hire someone or promote someone based on their identity versus making sure that those protected categories are not part of selection. Right now, the administration has not brought any cases related to pay equity, at least with respect to calling it illegal DEI. Christine, what am I missing here?
We're seeing for our total rewards, we have a mix of folks on the line, but for our total rewards leaders, one thing to just note is that the world that it impacts you the most is interestingly not on the pay equity side, but around stipends and allowances. So something to just keep an eye on is that what we're seeing in terms of those illegal DE&I allegations are around abortion travel stipends that are given to only women and not to men, for example, or in one case, vehicle allowances, kind of inequitable vehicle allowances, larger vehicle allowances for some groups that versus others, but not on pay equity. So do keep an eye on the fact that there may be more scrutiny around those allowances and stipends if you're a total rewards leader.
Christine and Rob, we had a two-part question come in that I think applies to this conversation. The first part around, what are your thoughts and recommendations on continuing to conduct an AAP type analysis for race and gender to ensure there's no barriers to entry, complying with either the prior regulations or state AAP requirements?
So maybe just as a background for folks that we've got a lot of federal contractors on the line, but not everyone's a federal contractor. So maybe we can talk about some of the ways that that an OFCCP style pay equity analysis may be the same and may be different. So the bigger the bigger the biggest difference for many employers is the way that you group employees. So unless you had a functional affirmative action plan that was approved at the federal level, you were grouping employees establishment by establishment. So locate physical office location by physical office location. And so you may have finance leaders that were in many, many different offices, for example, and they would only be compared to the folks that were sitting in their same building or sitting in their same affirmative action plan. If you had a functional affirmative action plan, that would be a little bit different. But for the most part, if you had just a regular AAP, you would be grouping in that way. You would also be grouping, looking at the grouping employees in PAGs. So your groupings may be a little bit different than you were doing for a pay equity analysis, but a lot of the commonalities were the same. So there's nothing that prohibits someone, if they were to want to continue to run their analysis establishment by establishment, if that was the way that you thought of pay equity. It's just that we find that very, very, very few people or very, very few organizations actually are looking at it that way. So that's why we're seeing a shift to people that used to do their pay equity analysis establishment by establishment and alignment with the OFCCP requirements to using to rethinking kind of how we may want to group that may better align to your workforce. And that's probably overly generous of the value of that. I think Rob thinks that he would never run an analysis establishment by establishment, but that's the
Potato. Yeah. It's whatever is best for your organization. I'd make whatever, however you think about your data in terms of groupings. I did it separately because the leaders really, we didn't run the business by facility. We ran it by function. We have so many questions.
I was going to say, I think a
You're
good
going to answer
follow-up.
some of
Yeah, a good follow-up question that came up was, with what we've covered today, do you think it's more critical to not do a race-based pay equity as the category of white versus BIPOC, and instead identify which race is paid the most in your approach?
Christine, should we discuss
You
it?
want to tag team it? You want to tag team it?
Yeah,
Okay.
yeah. We might
You
have a
want to
different
start?
view.
You want to start?
No?
Okay, I'll start. So the question is this. It goes in a couple of different, we get this question in like a couple of different ways. So the first question is, should we assume that white employees are the highest paid race and analyze white employees to that group? In the Syndio platform, you can analyze it in any way. So you can run white versus Black, white versus Hispanic, Latino, etc. You can also add a custom grouping and analyze it by any grouping that you want. Some employers are wanting to look at running those highest paid races, and that's something that both the Syndio platform and Katie's team is support, and kind of more to come on that from a product perspective. The other question is, are we seeing as many of the white versus BIPOC or anyone who's not white analyses? And I think it's still a little bit too soon to tell. I haven't seen a major shift on that, but I'd love to hear your thoughts, Katie. You're closer to that as well.
I would say it's a question that's coming up more often versus a whole shift to that approach, but it is being asked more as whether that should be the approach.
Yeah, I agree.
And for me, I think of it from an in-house perspective, which would be, I'd look at the way in which these cases are being brought. And so I don't see the administration bringing, for example, a case on behalf of Hispanic employees who are comparing themselves to Asians and saying, with these are most favored and these are least favored. Now I know that there are counsel out there who would disagree with me. I haven't seen those cases. And when the OSCCP brought one of those cases, it didn't go very far at all. Is that to say it's not going to? No, no, not at all. But I still the dominant group. I'd still look at white versus non-white, or a few iterations. If you wanted to do most favored versus least favored, that's fine too. What I'm curious to know is when we start doing that, or when companies start doing that more, the impact on remediation. I'd be curious about if that drives up costs or if it's cost neutral.
One of the questions that we had gotten, and it aligns to this, is what is the impact of the Ames case? So the Ames case is right now, the Supreme Court is reviewing in the process of it was argued on the 26th of February, but so currently under consideration by the Supreme Court is this case that's called Ames versus Ohio. And the Ames versus Ohio case addresses allegations of reverse discrimination. So it was claims of bias against individuals from my majority groups, in this instance, heterosexual employees. And Ames contends that these employment decisions were based on our sexual orientation, and that constituted discrimination under Title VII of the Civil Rights Act. And so there was, lower court decisions kind of back and forth on that, and the issue is currently before the Supreme Court. We would expect that there would be a decision by probably the end of the term, by June of 2025, and it could place the evidentiary burden on the making it easier to bring those reverse discrimination claims, and that's part of the reason I think that it's like part of this constellation of issues that employers are thinking through those things a little bit differently. So the things that we're seeing changing the most are ensuring that you're running your analysis and making adjustments both ways. The vast majority of our customers are doing that, but if they're not, they're beginning to think about it. But that second piece is exactly that, is like, what do we want to do in terms of highest paid race analyses in addition?
We had one more question that I think is relevant to the table on this slide, which is, do you anticipate that a company that continues to conduct race and gender analyses of hiring and promotion would be targeted for investigation by a federal agency?
I don't. I mean, you're still independent of affirmative action plans. You still have an obligation not to hire based on race or gender, not to promote based on race or gender, not to pay based on race and gender. And if you do, if you have there's still private enforcement, right? In fact, we'll show you in a moment. Most of the judgments in this area, most of the enforcement action is private litigation, not the federal government. So personally, I would still prefer, if I were in-house, and I'm not your lawyer, I would still prefer to do those analyses to make sure that our processes and our systems are not unintentionally disfavoring or favoring one group or another. The good news is, well, the good news, if I'm in-house, the good news is I don't have to report it to anyone, but I can at least look inside. And then if there's a systemic issue that it seems to be happening, you have an early detection, and you can monitor and adjust. Some might say, well, doesn't that mean I know the problem? Well, yeah, but ignorance of the problem is not a defense in any of these, right? If you don't know it, but you have a problem that's where you're disfavoring women in hiring, that's not part of the defense. It should an individual case or a class action be brought. I see Christine's typing. There's answers. Katie, you're going to answer some, but in the meantime, look. So Robbie Starbuck is very polarizing. He is, and we are not giving him a platform here. But this is to say, even Robbie Starbuck, an anti-DEI activist, maybe the most notorious anti-DEI activist, says that pay equity remains crucial. This is what he said a few weeks ago. That's a direct quote. Okay, so, and his point was, and part of the discussion was, when there's a problem, do you only remediate one way? And so we'd love your answers here. Again, this is anonymous. No judgment. If you only remediate one way, and this relates to, the question here is specifically with respect to white men. And then in a moment, we'll share with you what we tend to see in terms of who needs remediation when analyses are conducted. While we're having results, Katie, are there any of those questions that I think you were going to answer live that you wanted to address or haven't yet?
Not a question, but I think a call out from one of the attendees that I provided a lovely summary, just saying their take on this, practically speaking, of what they're seeing is ensuring that there's a bi-directional approach to your analysis. Because really the perspective of the flavor and tenor of these executive orders is that potentially those in protected groups were getting favoritism over those in the non-protected groups. And so taking an approach that allows you to review both sides of the equation, which aligns with our best practice as well as our technology. So I think there's just an astute observation I wanted to call out.
What do you think there, Katie? You
Yeah.
see what happens. How does this align with your expectations?
I would say of our best practice is to look at this bi-directionally and typically how we work with our customers and we guide them. And so I would say I'm excited to see those who are saying before yes and after yes. For those who are potentially changing their opinion, that kind of 10% of before no, after yes, we're gonna, I think, continue to see that number increase as we progress in the year. That's where we're hearing a lot of our customers ask questions. That wasn't an approach they took previously, but that's the approach that they're proposing for their coming year. For the before no, after no, we do have some who are taking this stance as well. And in this case, this would be an opportunity, I think, for us to connect and align together on where this approach might make sense and where it might not.
Hey, this is your data.
Oh,
Your
yeah,
your
I'm
team
happy
did
to
the
talk
work.
about it.
Your
Sure,
team did the
yeah.
work. I'm happy to take credit, but I didn't do the work. So
So I mentioned in the beginning that we have the pleasure of working with a large number of customers who've given us their permission to use their data in anonymized and aggregated fashion. We took a recent sample of analyses that had been run that covered over 400,000 employees to understand where are we seeing gaps appear, both in gender analyses and race and ethnicity analyses. And the important takeaway is what we see within our work with these customers is that pay equity can impact anyone. And so when you think from a gender comparison, the overwhelming majority of the groups reviewed, 85%, have no statistically significant gap. But of that remaining 15% of groups where there was a flag, 1 out of 5 times it was the men who were disadvantaged and recommended for remediation. When we looked at the racial comparisons, we saw a similar approximate ratio of those not showing any statistically significant gap. And in this case, we saw that 9% of the remaining 16% of those groups had a meaningful difference for white employees as opposed to their peers that were being analyzed. And so wanted to share this data with you all as real-time data of how these issues can crop up across all sides of the equation.
we mentioned this earlier, and Christine can speak to this, having, been on the defense side at Seyfarth Shaw just a few years ago. But most of these cases are brought by private litigants, not the federal government. There's a number of class actions that are happening right now and over the past few years, you look at the largest judgments and settlements, and we define that as exceeding 20 million plus. That those are from private litigants. Remember, plaintiffs' counsel are not subject to these EOs. The EOs have not rescinded laws. You can rescind the regulatory program, right? Christine and I talked about this. The president can giveth, and the president can taketh away. So it would make sense, whatever happens with litigation, if an executive order can set up a regulatory scheme, it would seem that an executive order could then remove that regulatory scheme. But no matter what happens, the laws ensuring equal terms and conditions for people in employment, regardless of race and gender, exist. And if there's a problem, plaintiffs' counsel are more than happy to seek enforcement. Christine, I see you moving.
Yeah, if if we think of the executive order 11246, that of course established the core non-discrimination and affirmative action requirements facing federal contractors from a sex and race ethnicity perspective at the EEOC, or excuse me, at the OFCCP, and of course that's gone. With that goes the monetary settlements that the OFCCP would have enforced on the grounds of Title VII or the Equal Pay Act. But that's not really where that action was anyway. Of course, it was very much a part of why someone would stay on top of all of that. There was a rigor that was associated with being a federal contractor, but the risk is not there. The risk still remains with these private settlements, and we saw that even this week. You may have seen that Google agreed to pay $28 million to settle claims that it favored both white and Asian employees. And we're continuing to see these big dollar settlements, $100 million type settlements, $28 million settlements like we saw with Google, continuing to be the biggest risk area. So I think that the biggest thing I would say is that, moving back and kind of radically changing the direction, you're really opening yourself up to those big claims as well.
And that's a good point. And I think one of the, we've talked about this where I think the Plaintiffs' Council have gotten wise to you can have perfect pay equity when you control by level, right? A couple of those settlements that Christine mentioned, or at least a couple of the numbers that she mentioned, were less pay equity issues and more systematic underleveling cases, right? That is, yeah, we pay every level 8 and level 7 and level 6 the same within the level. But the truth is, I'm funneled to level 9 and Christine's funneled to level 6. And maybe as a matter of negotiation, maybe because I'm no one asked me my prior salary, but I demanded more, and so I demand a higher level because that's a matter of negotiation. Pay may not be a matter of negotiation at some of the large tech companies, but sometimes level can be, and so we just share that because Katie and team can help you determine whether there's a systematic underleveling issue. You might have, again, perfect pay equity, and it used to be that plaintiffs' counsel were not wise to this some time ago. They've caught on.
I love this question, and you mentioned it a little bit. We talked about the fact that because the EEOC it's a bipartisan commission, and at the time there were three Democrats and one Republican, of which we talked about this previously, that two of them were fired. That does impact the ability to do those kind of big pieces of litigation, but it doesn't impact the kind of foundational piece of Title VII or the Equal Pay Act, which proceed. And often what we find is that if there's less action at the federal level, it often means that there's more action at the state level. We very much saw that with the last Trump administration. Still remains to be seen whether that happens this time around in response to what's happening at the federal level. But there's often that kind of countermeasure. And if we look at the times when there's been the most progress around pay equity, after the initial 1960s, when many of these laws were developed, many of them happened in Republican administrations, interestingly, or at least in Democratic administrations where there wasn't much action that was happening in this space. And we're seeing that certainly with many new pay transparency laws, more pay reporting laws kind of on the horizon.
We had one question while we're on the slide, and then I think all the other questions we're going to gather and save for our Q&A section. But one question that came in, Christine, that I think would be helpful is, We're talking a lot about the US regulations, and for the US headquartered companies that have populations outside of the US, do you have insight you can share on how these executive orders apply to those populations?
Yeah, sure. How if it, I just want to make sure that I didn't see the question, Katie. Is it, does the executive order impact, or are you?
Correct. Correct, or the
outside
executive
the US?
order. Mhm.
Yeah, yeah. The executive order would impact anyone that has employees based in the United States. So those, to the extent that we're talking about, or on the certification provisions, if you have a contract with the state, with the federal government, there can be requirements. So if you were if you were a federal contractor, you weren't based in the US, but you had employees that were based in the US, there could be coverage of the employees that were based in the US. It wouldn't cover your employees that were based in Europe or in APAC, or anywhere outside of the United States. They wouldn't be in scope of that. But to the extent that you were a contractor doing work with the federal government, you had those employees that were sitting in the US, they were covered, and that same kind of context would apply. In that same framework would apply in this way as well.
Great. I think from there we have another poll question. We're getting a number of questions
you want
around
to do it? Okay,
communication.
I'll do it.
Yeah, go ahead.
How are the EOs impacting how you talk about pay equity? And by the way, I was trying to respond to some of the questions in the meantime. And here we've given you a number of answers. I will not read them at you, but this is multiple choice. And so we just love to know if any of these capture what you all are doing, although we did get a sense that most are maintaining the course or even leaning in. But we were curious about whether the EOs have impacted your desire to talk about externally pay equity. It might be that you had disclosed your pay equity figures. Maybe you didn't. Generally speaking, up to January, companies were moving toward greater disclosure around pay gap and pay equity. And we'll see what happens over the next 46 months. While those results come in, there we go. Look at that. We are still beholden to the CSRD and EU and required to disclose. And then a good number are still determining strategy. That's where we find folks. By the way, if at any point any of you who are customers want to talk that through, or not customers, you can always ping some of us on LinkedIn or whatever. Happy to talk through it. We'll give you the disclaimer about not being your counsel early and often, but otherwise happy to share what we're seeing generally. Here's how we're thinking about it. Well, I'll say, here's how Katie and team are thinking about it, and the rest of us are agreeing. What do you think, Katie?
Yeah, we're definitely want to save the last 10 minutes for Q&A, so I'll be relatively quick here. But there's three key things we wanted to cover with you all is first that we are continuing to help companies stay in compliance and ensuring that their pay is defensible based on state, federal, and global laws and requirements. And as you heard through the conversation, our solutions help you identify where issues are cropping up regardless of who is impacted, ensuring that we are helping you mitigate your legal risk. From a second point, we do also offer solutions that help customers go even beyond pay equity and analyze pay policies agnostic of gender and race. We got a couple questions in there around how to think about outliers from your pay policies and practices. So we have solutions to help you think about that. And we're seeing more and more of our customers embrace an approach that looks at both pay equity and pay consistency. And lastly, we truly believe here that the future of compensation is a blend of being both intelligent and compliant. So leveraging AI, data, scalable technology, and analytics in close partnership with our advisors and customers to enable this new future. So if you want to learn more about that, please reach out. We'd be excited to talk to you about it. But with that, we're going to turn to our questions. And we have a couple more questions in the chat. One of the ones that we covered at the very beginning, but I know a couple of people had to join late, which was just what is the impact we're seeing overall with organizations in terms of their focus on pay equity? Are people doing more or are they doing less? Rob, Christine. your thoughts.
Katie, do you want to give the context from before? I mean, what we were seeing, it looks like that most are staying the course on that, and that's really what we're seeing. The risks are still there. The risks that we see, most of the cases, you have risks that come, there is in fact probably more risks because you're facing an increasing number of, an increasing number of reverse claims at least being talked about. We have the Ames decision at the Supreme Court level, but there's still a lot of claims that are happening. And I put reverse kind of in quotes, but like, there's a, sorry, Rob, but we also have all of the risks that were there in advance of all of this executive order, and in a very hot landscape, of course, with the EU and all of it. So I would say we're certainly not seeing a big retrenchment at all, or a retreat at Cydio at all.
Right. We have another question around this topic of communication. How are companies navigating this tension between maintaining this commitment to pay equity that you just shared and potentially modifying their communication strategies in response to the current environment?
Katie, talk about, I mean, your team does so much of the communication. I would love to hear your.
Sure, I'm happy to share. What we're hearing a lot from our organizations is thinking of a rebranding effort and how they talk about the phrase pay equity. So still a focus on the work, but a potential rebranding. We've heard pay fairness, we've heard pay audit, we've heard pay consistency as some of the phrases that people are leaning into and using. I would also say that organizations are evaluating how they talk about their methodology in their public statements. So ensuring that it's clear they are looking at pay equity if they are bi-directionally, and sharing that in their communication as well.
And I think that's, by the way, just what you just said, I think answers how I was going to answer one of the last questions that came in terms of what are the main takeaways. For me, the main takeaways are pay equity will continue. Pay equity is quintessentially anti-discrimination. The change may be for some companies. There were some companies that were a little bit more brazen about not remediating when they found men disfavored, as an example. Now, mostly they weren't. But for those times that were, you may want to rethink about whether you remediate or whites or historically underprivileged groups being remediated only and whites not, or the intersection of them. I think that companies will do a second look at that because they will be a little bit more sheepish about openly saying we're not going to remediate certain groups. We're just going to remediate those non-dominant groups. But that's why Christine mentioned and chuckled before. We talk about reverse discrimination cases. That I said we have another term for them. It's called discrimination cases. Again, the Title VII doesn't make an exception. There's some judge-made law around dominant groups or historically underprivileged groups, but the framework of the civil rights laws protect the categories, not certain people, and everyone's in those categories, even white dudes. It's just that we're mostly not disfavored.
We had another question that came in about the tension between the pay transparency directive in the EU and the executive orders that we talked about in this conversation. Anything you could share about how these global organizations who are beholden to both should be thinking about their approach or their strategy?
Yeah, I think that you can't, the amount of work that is required by the EU Pay Transparency Directive is just really enormous. And so employers that are thinking through their strategy, we're finding that the temperature is raised this year, really focused on correcting that. I don't see that tension as much on the EU Pay Transparency Directive because you're reporting just on your employees in Europe. In the US, you're reporting your employees based in the US. I see a greater tension between the CSRD and so the corporate sustainability requirements, because those corporate sustainability requirements require that you're also publishing pay gaps, one pay gap number that includes your employees that sit within the US. You may have seen that is under legal, that there's a bill right now before Congress that would basically exempt employers from having to report on information and sustainability requirements for their US-based populations. Not sure kind of where that's headed ultimately, but something that we're keeping an eye on. So less tension I see on the EU Pay Transparency Directive because the populations are separate. EU Pay Transparency Directive only covers your employees that are based in the EU. The requirements in the US only impacting the employees that are sitting in the US, but I do think that there may be some tension between the CSRD.
Great. We had a question related, Rob, I think, to the point around employees who are working for US embassies sitting in Europe, where there's reporting requirements. Any insight we think we can provide relative to Trump's executive order?
Yeah, I'll look in my magic 8 ball for the Trump administration and shake it up. And I mean, my own guess would be not anytime soon because they have bigger fish to fry, other battles that they're fighting on every front in the US. But in terms of is it not possible, especially given the administration's position with Europe generally right now? I mean, right now, I find it impossible to predict the administration and what actions they might take. So it's a fair question. It's one I wouldn't even thought about.
Yeah, I was thinking about that. The other piece I think has to do with how much of the focus is around pay equity.
Mhm.
When the sustainability requirements was largely around the environmental piece, like the impotence behind that was driving it was less around the D and I intersection, a little bit about that, but a lot of it around the sustainability impacts of that work. So that's something that may or may not be kind of part of it. Interestingly, like if we look at the lawsuits against the law firm or the requests for information from the law firms that recently came out, it's not talking about pay equity. It's really focused on, at this point, they're so very focused on selection, diverse slates, rotational programs, that type of thing, that seems to be where the focus is.
Right. We only have 2 minutes left, so why don't we just close out with one final question? If you asked a question that you didn't get answered, we will be following up with answers to the questions that we can provide answers to after this. But final question for Christine and Rob, what is the #1 takeaway you want our audience to have from this conversation? Rob, I'll start with you.
I'd absolutely continue with pay equity analyses, and I'd actually lean in more because right now companies are pulling back on all of the behavior and activities that would be front and center if you were sued, and they would be part of your defense. Apple's facing a class action right now. They're going to defend themselves. It's a gender class action alleging women are disfavored versus men in certain groups. They're going to typically, when you defend those, you'd roll out all the things you were doing to make sure that women have as much exposure to opportunity as men. Companies now, I'm not saying Apple's doing this, companies are pulling back on those efforts. That's a short-term mistake that will hurt them. I think when plaintiffs' counsel catch up, all those things that would be part of the defense are being pulled back.
Mm-hmm.
And the sharper teeth on enforcement is private. So I would lean into it, and I'd also keep an eye on that on the systematic underleveling thing that we mentioned.
And I would say exactly the same, also because of all of the pay transparency laws. So a lot of your compensation is really open and transparent now. So we have pay ranges that are out there. Employers have been answering and being asked questions about how pay is set within their organizations. We have the EU Pay Transparency Directive that's going to require unprecedented amounts of transparency, impacting many employers. And all of those reasons, like less the law piece and more those other reasons that that if you're not able to answer those questions, it just creates massive morale problems for employees too. So I think that would be another reason that I wouldn't make a big shift.
Great. With that, we really appreciate you joining us for our AMA. As we mentioned earlier, this was recorded, so we will send along a link to the recording as well as a copy of the slides, which will include reference links for some of those materials that were covered today. Thank you again for joining us, and we look forward to continuing the conversation.